Hello guys, big news, or maybe not. Movement in the filing dates for EB2 India, significant movement. We're going to discuss it, break it down, analyze it, and give you options when we come back. All right. Hello, everybody. I'm Sam Shihab.
I am Brian Burke, and I just touched my microphone. That probably didn't sound good to our audience.
Ouch. Hopefully, you didn't hear anybody's ears who's having headphones on listening to us. Yeah. We are from the law firm of Sam Shihab and Associates. We do this weekly discussion about breaking news, current events, and the employment-based U.S. immigration law. And this week is an interesting development. We have a significant, unexpected, unpredicted movement in the EB2 dates for filing for India. There's other movements as well, which we'll bring, but the big one is that that massive 10 months?
More like a year, yeah.
About a 12 months movement. Yeah. And it's like, okay, what does that really do for us? So let's go into the details into that and talk about it, Brian.
You mentioned the unexpected, but let's talk about what was expected. And let's pat ourselves on the collective head, Sam. We sort of predicted a visa bulletin movement in EB2 of about 2.5 months. And that's what final action dates. And that's what we got. Yes. So, we try to avoid predicting the visa bulletin. We foolishly did some predictions, and it seems pretty good.
But if you predict it every month, for a year, one of them is going to come out right.
This is true. More often than not, your foot's going to go into your mouth.
Yes, but yes, absolutely a good accomplishment for us that we've predicted this one correctly.
Yeah,
correctly predicted the EB3.
Yeah, EB3 staying as it is.
And that's what we predicted. Yeah. That it will be no movement this.
Yeah, where we don't expect to see that to move until realistically October, when the new fiscal year begins.
Yes.
So then there's what was unexpected. It is the 1-year movement in the dates for filing for EB2.
And we are perplexed a little bit, and we are going to tell you why it happened.
Our take on it, at least.
Through the analysis as we break it down for you. Brian, you have a screen here to share?
I figured I would just put it up as a point of reference. There it is for everybody. There's the dates for filing on the new visa bulletin on April 2022. Yeah. Again, dates for filing, date is 1st of September 2014 for EB2, and that's the big, huge change. And we haven't mentioned it yet, but it's worth noting, USCIS is accepting that date. So Department of State put it out, and USCIS immediately said, hey, we are taking that date for filing, and this is surprising, Sam, because traditionally they only do it for a short time after the beginning of the fiscal year, and now it's April, and they're still going to be taking it.
And we are going to talk about also why we think that's the case for accepting dates for filing, where traditionally they have not accepted the dates for filing.
Yeah.
Before we go into the theory of it, shall we discuss what does that really do for people? Who are the people really most impacted?
Yeah, we can hit upon that first, for sure.
Yeah. So if your priority date is between, and I got it written down here, so don't mess it up, between July 8, 2013 and September 1st, 2014. If you are in that window of time, you are pondering whether or not I should, and if you do not have an EB2 case filed already, you would be pondering, is this a good idea for you? Now, USCIS came out also with a release, just like they had a release on interfiling, they had a release on what to do and what you should be doing, which also is very interesting.
Yeah, I don't know if I want to get my legal advice from USCIS directly, but let's put up on the screen what they sent out here right quick. There it is.
And I like the heading. USCIS urges eligible individuals to consider applying for adjustment of status in the EB2 category based on the April visa bulletin date for filing for India. Now, you notice here, they did not say urge you to interfile based on the dates for filing because...
Well, they already did that, you know.
Dates for filing.
Well, yes. Oh, yes. Okay. So they don't urge you to interfile based upon dates for filing because it's impossible.
Because you cannot.
Yeah, you can't do it.
You have to do it based on final action dates.
Yeah.
And in this in this write-up, the USCIS has confirmed that they are aware of their prior interfiling recommendation.
Yeah.
So this is not somebody writing something who is not aware of what USCIS has said before. Why is that significant? It's significant because they're aware that some people can interfile, and they're also aware that a lot of people have EB3 adjustments. Because at the bottom of this write-up, if you scroll down, Brian,
yep.
as previously announced, we continue to encourage, if you can make it bigger here.
I can.
Yeah, here you go. As previously announced, we continue to encourage eligible applicants to consider requesting a transfer of underlying basis, and these are from EB3 to EB2, based obviously on visa availability.
Yeah.
Now that is previously announced, that's not here. So they're aware of that. So they're also aware that they're talking to you, and you also have an EB3 most likely in the pipeline.
Yeah.
Now, they are not saying double file. But
they haven't gotten quite close to that,
but they are as close to it I've ever seen before.
Yeah, and you know, we don't know exactly what their thoughts. We know it's not, you know, you're definitely allowed to do multiple filings, but I can't imagine that somebody at USCIS really loves the idea because they get double the work in theory, right?
Well, historically they've discouraged that.
Well, that's why the whole interfiling policy is there. It's, hey, save us the work of an extra case.
But this write-up here definitely encourages you to file an adjustment, not a second adjustment. They didn't say that.
Yeah. But I mean, the whole policy encourages people to file adjustments because, again, the final action dates are pretty far off. But they move those dates for filing ahead a year. And what can you do when your dates for filing are current? All you can do is file an adjustment. They are basically
so to encourage you to file an adjustment. To me, I read into it that we're not going to say file a second adjustment, but we're giving you all the hints in the world. You should file a second adjustment. Do you read it that way?
Yeah, it's hard to really read it any other way. It's that memo says, "Hey, you can file a second. You can file if you can file a second adjustment." It doesn't say second. You can file adjustment of status, and those folks who you know, it references those interfiling requests. It's really saying everything but that. Agreed.
Because if I am not encouraging you to file a second adjustment, I wouldn't say I encourage you to file an adjustment. I would say you should file an adjustment because now it's available. Yeah. I would not say I would encourage you to file. For me, the word encourage you is giving you this hint. Are we reading into it too much?
I don't know.
We're lawyers. We read into everything.
I mean, but you know, I try to take what the government says at face value because I, generally speaking, believe in what the U.S. government says. They try to be forthright and honest. Mm-hmm. But, you know, we're going to sort of talk about, you know, more about their motivations and what the motivations might be and what's going on here as we move on here.
Yes.
And it's worth talking about what, you know, is this just a bunch of hot air? You know?
Is this big news or is this not big news?
Well, so really we're going to get into what's the meaning of this, I guess, right now. This is when we move on to that, right?
Yes, I think so. We just need to just look into what the heck is going on. Why movement in the dates for filing? Yeah, so, you know, we were talking about this beforehand, and my one thought on the subject is, you know, the way the Department of State moves the visa bulletin is basically if they are trying to eat up their visa quota that's available for the year. And if they move the visa bulletin, Sam, that means to me that visas are available, and they don't think they have the cases to process them. And the dates for filing is a forward look at where the dates are supposed to be. Meaning, you know, give us. It's, to me, this movement on the visa bulletin says we anticipate that we're going to need more cases in the near future based upon priority date available, where we expect final action dates to be. So send us those cases. Okay. So recap. There are two dates. Yeah. You're walking the timeline going that way. Dates for filing. Yep. Final action. Yeah. Right. The one further away is final action. Sure. I'm going to turn it here to to my, if I do sideways.
Perspective is hard, yeah.
It's very hard. Here you go. Because I'm confused here when I look at the screen. All right, so the idea is dates for filing is to allow the government to receive your case,
pre-process it,
and prepare it, and as they approach the final action date, the case is ready.
Yeah. So
that date turns on, and they say next morning, boom, here's your green card.
So they can give you a green card as soon as you're truly eligible for it. As soon as the visa is available. Well, conveniently, we just finished up all that pre-processing, and now here's a green card as soon as your final action date's current. That's what the intent is.
So the State Department published those dates.
Yeah.
USCIS says, I'm not sure I want to play. Many years ago, right?
Yeah,
I don't like this game.
When they first started doing this.
I don't like this game. This game, I don't know if I can handle the workload.
Yeah.
I'm not playing. I'm going to have my own visa bulletin, right? So now they're going along with what the State Department is doing.
Yeah, and I mean...
So there are two questions. Why the State Department did what they did? Why USCIS is going along?
So my first take was, when I was saying it earlier, was mainly about Department of State. The Department of State, they really control the visa bulletin, and it seems to be their opinion that they need more cases or to use these visas. And if USCIS is taking those dates for filing as well, I guess they have to agree with the Department of State. You know, they both say we need more cases to eat up these visas, this massive visa availability for this fiscal year.
Not necessarily for this fiscal year, though. You know, the concept of filing action is a rolling concept.
Yes.
So it's a kind of an attitude that continues all through jump from one fiscal year to the other.
Well, yeah, you're right, and we know I think Charles Oppenheim, before he retired, said, you know, the visa bulletin, the dates for filing are supposed to look ahead to like 8 to 12 months in advance, and 8 to 12 months in advance is outside of this fiscal year already.
Exactly. Not only that, but also the USCIS. They don't work on cases when they receive them when the final action date is not current.
Yeah.
They shelf them.
Yeah.
They put them on the shelf. They take the check, they cash it, they put it in their coffers, and then they put it aside.
Well, Sam, you know, I think we're maybe segueing to, you know, what your take on this might be. Why would they do that then? Why would they take cases that they know they're going to put on the shelf for a while?
Okay, so the first one that you think, I'm going to give you credit for the first one, since it's your idea, the cynical view.
The cynical view.
The cynical view.
Yeah. It's a money grab. You know, they get to take money for cases.
They need money.
They need
Give
money.
me money.
Yeah, and the cynical view is right now, if they're encouraging all these people to file based upon in April, based upon this April visa bulletin that moves ahead a whole lot, right? And even though the dates for filing look forward, indicating they think there's going to be a visa availability soon, we also, per our talk last week, basically said, it looks like they're on track to waste a ton of visas in this fiscal year. And, you know...
Same as last year.
Yeah, and, you know, the cynical view is they're going to take these cases knowing that they can't approve them in this fiscal year because, I mean, do we really think that they can take
or even touch them.
A case on April 1st and get it approved within 6 months? Anecdotally, we've heard that it's possible, but I am skeptical of USCIS's ability to approve a case in 6 months before the fiscal year ends and take advantage of the visa availability.
So the cynical view espouses the idea that they have went along with the Department of State to get money.
Yeah,
that's the cynical. We don't know that. We don't know that.
It's a theory. I mean, because when we first see these things, Sam, we have our gut reactions, and you know, and this is the sort of things that cross our mind. Why the heck do they need to Why are they doing this? Why don't they let these people interfile instead? You know. So
you give me that cynical view.
Yeah.
All right. You gave also an optimistic view.
Yeah. Change in policy, change in administration. More, you know, when we were talking, you know, probably in the last year about the visa bulletin, Sam, you know, one of our pro-immigration advocacy points is be liberal with the movement of the the dates for filing. Let people file early. Let them get some of those feel-good benefits, those things that bring stability to your life.
That's not the one. The optimist. Yeah? No, that's the one. Sorry, with all due respect. The optimistic view is they're still raising money, to hire contractors to process cases, and they need money to move your cases so they don't have wastage.
Sure. Okay, that is the most optimistic view. I guess what I was just espousing there was...
So the third one, I call it the honorable view. The third one.
Yeah.
And the honorable view is that they recognize that they should not induce because I think this is what Charlie did. He induced the idea of wastage in the movement of visa bulletin. And he did that last year, and that was very irritating. That they cannot get to them anyways. Why would I move it so I can retrogress it?
Because people want to file a green card so they can get the benefits of that stability it brings to their life, and that's what we were talking about all last year. And that's what I was talking about. My honorable, and basically
the honorable view, which is the third view. So we had the cynical view, the optimistic view, which is basically they need money.
Getting those green cards out the door. Yeah.
They need money to hire people to process your green card, and they don't have the money to hire contractors. So they're moved the filing date so they can get money.
Yeah.
They already spent your money on something else, so they want somebody else's money to handle your case.
So they take a second case, which they probably don't really need, but they use that money to basically beef themselves up and get those cases out the door.
And the honorable view is that they realize that they should not put the idea of wastage in the visa bulletin movement calculation. Yeah. And that is the honorable view, because putting wastage is dumb. It's dumb. And move it if the calculation points to a movement, and give these people the additional rights, the EADs, the advanced parole for the children, for the family, for the kids.
Even if they think they're gonna waste the visas, don't penalize the people whose cases you don't think you can get to.
You may not like the retrogression later on, but don't hold these benefits.
Yeah.
I don't like retrogression. Nobody likes retrogression, okay? But don't hold these benefits for people. So that's the honorable. Yeah. Now, which of the three? 1, 2, or 3?
I kind of like the honorable one. So on the cynical one, the U.S. government, sometimes they don't do things right, but they're not. That's just pure. It sounds like pure evil to me.
For me, it's 6.
6.
1 plus 2 plus 3.
A little bit of all these.
A little bit of each, divided by 3.
Well, I like the honorable view. That they are trying their best.
I think there's a component of that.
Because the bottom line for me, Sam, is we talked, and we still have that data here just to remind everybody. They have, 280,000 green cards available this year, I believe was the number?
Yes. I have to go back to my number from last month. I think I put that down.
Yeah, but and I'm going to put this chart up here right quick to show everybody how USCIS is doing. Yeah, about 280,000. So there's our PowerPoint, and there it is. This is, right here is how many visas they have available, and this is how many they gave out. In
the first quarter.
Yeah, that's just at USCIS in the first quarter of fiscal year 2022. They approved about 35,000.
That's ending in January 1st, 2022. The first quarter.
Yes.
So between January 1st, 2022 and now, we do not have data yet. But they just released last week or 10 days ago data for the first quarter, and it was miserable performance.
Disappointing, because they had to do a heck of a lot better than that to issue all these green cards. So, we're talking about putting a bunch of new cases out there in April, and that's, I don't see any, do you see any chance of them approving, if you file your case on April 1st, Sam, your shiny new dates for filing based EB2 adjustment of status, do you see any chance of them approving those cases in fiscal year 2022 when visas are at peak availability?
Well, I'm going to give you an answer and a question.
Yeah, okay.
The answer is no, I don't see a chance. The question is, so what? And I think what we need to do, and that's why people listen to us, to give people advice on general broad terms, what should they do? I guess that's why people subscribe to us. What should you do? And if you haven't subscribed, Brian loves those subscriptions.
I get notifications on my phone. It makes me feel good. I look at your YouTube profiles to see who you subscribe to. It's fun. I'm the guy who answers comments on the channel. It's fun.
So this is your chance.
You're entertaining me.
Yes, absolutely. That's why they're here. That's why they subscribe, is to know what should they do with this visa bulletin movement.
So I just gave the dour view that they're not going to probably not going to approve these cases in this fiscal year, and you kind of agree with that. I think there is a narrow, possibility that if you are eligible to file based upon these dates for filing now, there is a non-zero chance, a greater than nothing chance that you could get a green card in fiscal year 2022. If that's enough for you to file the case, that's a great motivation for you. However,
I'm sorry. Let me clarify this, Brian. There is no chance for people to get their case approved if you file your adjustment now.
I give it a very, very, very narrow chance.
If you file the underline, but if you had your adjustment pending for a long time,
oh, great.
You could see improvement. Now, for those whose priority date, Brian, between July 8th, 2013, that's the final action date, and September 1st, 2014, that's the date for filing, in the EB2 category, born in India, with the assumption that if you file the adjustment now, you will not get it approved in this fiscal year. Would you recommend, and if they have an EB3 already pending, would you recommend that these people should consider filing an adjustment status?
I mean, that's a personal decision for you, but the benefits are the following. One, you have a second adjustment status pending, gives you the protection of having another case pending that allows you to stay in the United States, and you get the EAD and AP associated with that. Second, anything we see right now, the EB2 dates are ahead of the EB3 dates, and meaning it seems more likely that you're going to get your green card sooner in the EB2 category, which means you want to be in the EB2 category. And if you're in the EB2 category, you're taking advantage of right now, the dates for filing for their intended purpose. Get your case in with USCIS so they can pre-process the case before your final action date is current. And maybe your final action date will come current in this fiscal year, and maybe it'll be a miracle and you'll get your green card. But if it's not this fiscal year, eventually your final action date will come up, and everything we're seeing right now is that it's likely to come up in the EB2 before EB3. And the worst case scenario, if things slingshot back and forth as they've done a couple times now, and EB3 pulls ahead, well, you're still in the EB3 category with the other case. You are, we've talked about the sort of Rolls-Royce, grand regal way of immigrating. It's get yourself in both categories, file adjustments in both categories, and then you don't have to worry about, you don't have to like, follow, and subscribe to hear our updates on the Visa Bulletin. You just have to basically know that you have two cases pending, and they will approve whichever one of those they can get to first. You don't have to worry about it anymore.
I compare the philosophy of not filing to save money versus the philosophy of filing to create opportunities is between a company, and maybe I'm digressing, a company that focuses on saving money and a company is focusing on generating revenue. While saving money is a great thing, it's always limited by the amount of money you can save. You can save 10%, 20%. Generating funds, as a company that focuses on generating funds, the upside is unlimited. So for you to say, well, these lawyers are trying to take advantage of you and charge you more money, that's nonsense. But it comes from a mentality. If we come from a culture that is really focused on saving money, it's hard for us to switch that mindset into, I'm creating opportunities. What are my opportunities if I get my green card 5-6 months earlier or 3 months earlier? Maybe not. But what are the upside for me for financial aid for my children? Opportunities for me or opportunities for my wife, employment, etc. So there's a great upside, intangible, and if you are a kind of a person that's focused on the upside of life, then this is for you. If you're the kind of person who are stuck in the world of I want to save money, which I don't think this is a healthy way of thinking, but if
that's
you're
how
stuck,
I think, Sam. I'm a cheapskate.
Well, then why would you recommend adjustment of status?
Because, so in the back of my mind right now, there's the option of, well, what about waiting for your final action date to become current, Sam, and interfile? So, but ultimately, Sam, I'm born in the United States. I don't have the immigrant experience, and but I talk to people all the time who have been waiting for their green card. Lots of folks from India have been waiting for their green card for a decade, and anytime I talk to one of them, it's I don't care about the money at this point. It really is a case of I'd rather have the green card a week sooner than have to deal with this insanity any longer.
I'm talking to a gentleman who is consulted with me. He tried to reach me on the weekend. I was traveling. We couldn't connect. Finally, I talked to him at 8 a.m. this morning. The conversation was, my daughter is in medical school, aged out long before their adjustment still pending, but she could not be included. And now we're talking about what kind of visa to get her into, what kind of residency, and what kind of. It's a mess. Now, there's nothing he could have done. It's not like he had a chance to do another adjustment and he didn't do it in that example. But the reason I'm saying this is that the consequence of delayed adjustment financially on the family could be, not all the time, could be serious. Yeah. So yeah, I think filing a second adjustment for me is a no-brainer. And those that says, well, it's wasting your money, relax, relax. Yeah. You know, this is your future in this country. This is your green card. Get both of them and forget about it.
Yeah. So, well, if you don't do that, I mean, what if you're pretty close on final action on EB2 final action date, Sam? I mean, you could wait, until your final action date is current and then do an interfiling request. Yes.
Yes, but obviously, I mean, that's fine. That's fine, and you can do that absolutely. But you've abandoned the EB3
category, path. and here's what I was thinking about this earlier today. If they're encouraging everybody into the EB2 category, and then they're about to waste a bunch of visas, I can't help but foresee a scenario where EB2 gets full up, and then EB3 it's a wide open space, and thereby the dates move up for EB3 again.
Would you interfile the EB3 if the EB2 becomes current? If the EB2 becomes current, the EB3 is current. Yeah. So I don't think interfiling is advisable.
I don't. Well.
But I think it's a bad idea. Well, as suggested by USCIS, they don't want you to do that either.
Well, yeah. I mean, I've talked to people about this, but it's very tempting to people because they're putting out all these mouth-watering press releases saying, we have tons and tons of green cards available in the EB2. And I've talked to people. I said, you're current in EB3 right now. That means they're saying they have a green card available for you right now in the EB2 category. But the trust for some people in USCIS and their ability to actually approve cases
because they can retrogress it. They can retrogress it, then file a second one. Yeah. File a second one and don't worry about it. Yeah. It's expensive, I know, but it's your future.
Yeah. So it's once speaking of the concept of retrogression, Sam, one thing we have to mention is the EB5 program.
Yes, it was raised last time.
It's a common question we're getting. What's going to be the impact of EB5? And it coming back, Sam, another feather in your cap. You said yes, it's been reactivated, it's been reauthorized, EB5 program, but it's not going to really impact the Visa Bulletin, and that's kind of the impression that I get on the Visa Bulletin. On the Visa Bulletin for this month, April, or the coming month, April, it says they acknowledge it, but say more information will be available on the coming editions of it, and thereby. The way I read that is, no impact so far. Yes. But it's, about 10,000 visas that are at play there for the EB5 folks.
7% of 140,000 is that. Okay, excellent point. So that's what we got on the Visa Bulletin. I see a lot of questions lining up here. So when we come back, we're going to take all your questions and hopefully can answer all of them.
Well, welcome back, everybody, and here we are. And I already put a question up prematurely, but I think it's a good one, and it's one that's kind of been on everybody's mind. And it kind of influences people's decisions upon how they act based upon the current Visa Bulletin. It's, will there be any movement for EB3 for the rest of 2022? Would it move ahead in October 2022? So,
well, would there be? I think we are standing behind we don't expect movement in EB3 for the rest of 2022 fiscal year.
So meaning in October 2022, that's when we think there's a possibility of movement, because that's when the new dump of yearly visas becomes accessible to the government.
And I am not going to say, and if there's a new legislation, things can change.
Yeah.
I am not going to say if there is going to be new legislation, things will change.
Well, as our discussion.
Did I say that? Oh. I said I'm not going to say that.
Well, our discussion of 2 weeks ago is essentially our roundup of legislative activities, and basically they all seem to be stuck behind in a logjam behind the Build Back Better Act, whether they're going to act upon that.
I think if we stop saying that word, Build Back Better, I think we may have better luck. I think Build Back Better is out. I think we have to say something else.
Undefined future visa
Legislation,
recapture.
which we are not going to talk about or hope that will pass because we're tired of waiting for it. If it comes, we'll let you guys know. Okay. All right, so let's go on to the next question.
Yes. So if someone on H-1B who has EB-5 petition and they file I-485 now, if the petitioner maintains the H-1B, can their dependent on H-4 use EAD based on EB-5? In case of I-526 denial, can they go back on H-4?
Well, the EB-5, the answer is no. I'm going to give you the short answer. The EB-5, I-485, is no different than any other I-485. Once you use that EAD, you're no longer on H-4 because the H-4 does not permit employment.
Well, H-4 allows you to use H-4 EADs,
without the EAD,
but only allows you to use that specific category of EAD while you're in H-4 status.
Without an H-4, yeah.
This EB-5 adjustment EAD is a different EAD. They're like oil and water. They do not mix.
Now, would you be able to get back on H-4? Yeah, you would be able to get back on H-4, but you have to probably, she or he, the spouse, has to probably depart the U.S., interview at the consulate, and then re-enter again as the principal spouse maintaining their H-1B status.
Yeah.
And if I wouldn't worry about not working, this is not you're not making a major risk for the spouse. If the spouse received the EAD based on the EB-5, I would work. I'm not concerned about it. And if there's any issue,
well, yeah,
departing and re-entering is not a major issue as long as you're maintaining your H-1B.
Generally speaking, you know, an EB-5 adjustment, I mean, that's those are pretty serious cases. I'm not, you know, unless you're well aware of some specific issue. So, well, you know, I think we have a comment here that didn't quite get finished. But hi, Sam.
Hey, how are you?
We'll look for the rest of your comment later on. I just don't want to skip over anybody.
Yes.
Don't want to lose my place in line. So
received adjustment status request for evidence only for the primary for medical. Should I go ahead and submit for dependent as well? I submitted an I-693 form for both of us with original application November 2022. If your priority date is current, I would absolutely submit medical for all. What do you think, Brian?
Yeah, I think, well, here's what bothers me about this. If you submitted medicals in November 2020, they're still valid right now, presuming they were signed by the doctor recently at that time, you know, that goes 2 years from the date of signature by the doctor.
November 2020, yeah.
They should be good until November 2022. But if they're asking for them, you know, this is not the battle you want to pick. Yeah, give them the medical exams.
Yeah, I agree.
Just
good observation.
Bothers me, yeah.
Yeah.
So, do you have any better idea this week if EB-5, the authorization program, will eat into the 280K family-based spillover?
Well, the answer is yes by 10,000.
Yeah.
So, and Sweet Seller, I don't know if you picked up. Yes. I mean, the number per year is 7% of the 140,000, 9,940 visas. They're probably going to be eaten up right away by the EB-5 unless USCIS cannot approve all of them, wastage again, in which case they'll get dropped, whatever is left get used into the EB-2. So yes, by 10,000, correct. You will eat up 10,000 of the 280,000 maximum.
Yeah. So let me see here. So here's another one. So my I-45 was transferred to NBC last week from Nebraska. Priority date is 10/29/2021. 10/29/2021. That can't be correct.
Maybe 2012.
Perhaps, yeah. Is that a good sign? I-140 approved through PP already. So one of the things that I have heard and I believe to be accurate is the National Benefit Center is not processing directly themselves employment-based cases. Because when you look at the USCIS data upon processing of cases, they don't list the NBC as an office that's processing them. They list all the local field offices, you know.
They manage them, but they don't process them.
Yeah, they have NBC case numbers, but you know, they list in there who's processing employment-based cases, all the local field offices, Columbus, Ohio, Dallas, Texas, you know, anywhere, and then the Texas Service Center and the Nebraska Service Center. So I suspect that might mean, transfer to the NBC. It might mean they've sent your case to a local field office for adjudication.
From Nebraska.
Yeah.
Probably is going to a field office, probably an interview.
Yeah, but
is that good news? Let's answer the question.
Yeah.
Yes. It has to be good news, assuming your priority date is current, because your case is moving.
Yeah, if they're not looking at your case, it's sitting on a shelf. Your case is not on a shelf. It's out there in the world moving around. I call that good news.
I call it good news, yes.
Yeah.
Can we apply and use H4EAD while already have I-45 EAD? The answer is yes. Do not want to use 45 EAD right now while waiting for final action date to be current due to the aged out kid. I will comment on that in a second. I'm still maintaining my H4 status.
So I want to comment on this briefly because when there's having the I-45 EAD, not a problem. If you're using the I-45 EAD every day, you have a problem with getting into H4 status because that is incompatible with it. But it doesn't say you're using it. So.
But what's the due to aged out kid?
So
now, while waiting to final action date, due to aged out kid, how can using the I-45 EAD impact aging out? Is my question.
I don't know. You seem to have an answer locked and
No,
loaded.
no, I do not have an answer locked and loaded. I have a question that I do not have an answer for. I do not see how a 485 EAD causes an aging out unless they want the opportunity to file a second adjustment.
Based upon a longer pending I-140 that could still save somebody. That's a good scenario.
So you filled in the gaps pretty quickly. That's a very good answer. So if you have another I-140 for, let's say, EB2 that has a longer processing time, it took a long time to process, that it gets credited back.
Yeah.
And that could be a scenario by which using the 485 EAD can help an aged out situation, but it is not a normal situation.
Yeah. I mean, so I'm just going to kind of remove the middle sentence. Can we use H4 EAD? Can we apply and use H4 EAD while we have the I-45 EAD? I'm still maintaining my H4 status. The answer is yes. If you're maintaining your H4 status, keep on applying for H4 EADs.
Yes.
Great.
Yes.
You can as soon as you use that I-45 EAD, you leave behind your H4 status. Though.
And Aishita, if you can elaborate for us on this aged out in a subsequent comment, I'd love to further dig into it because it sounds like there's an interesting thing here that we can discuss. Thank you.
Here is there's a follow-up on that question about the movement of my case to the National Benefit Center. My priority date is ROW and current. What is ROW? I know we figured this out before, and it's going to seem really obvious to us when we stumble across it.
Yeah.
But if your priority date,
I know what POW is.
Yeah, POW of I can't.
I'm messing with you. I do not know what ROW is. Please, I'm sorry.
Sometimes the acronyms get lost.
You guys on the chats all the time. We're not.
Yeah. So we'll just keep on going. I mean, the bottom line, if your priority date is current, they should be working on your case, and that they're moving it around indicates that they're doing something with it to try to get it approved. So that's a good thing.
Yes.
So from Raul Roy, if my spouse has used dependent AOS EAD but has not been 180 days since she started using it, can she use 245K to refile EB2? That's a great question, Sam.
Well, the answer is yes. Brian, elaborate.
The answer is yes.
Yes, maybe, because it depends on the counting of the 245K.
How much time? There's the dates you say you've used, and there's what dates the government thinks, what days the government thinks you might have used. Right. I guess if you're at 179 days, great. But all the government has to do is find, 2 more to put you over 180, and then they have a grounds for denying that I-45 case.
But it sounds like to me a second
adjustment,
and therefore it's worth taking the risk after you do a good, careful analysis. It's not the end of the world.
This is true. But you could also, assuming that somebody's maintaining, it says, I'm going to read into Raul's question. He says his spouse has used dependent AOS EAD, which kind of suggests that maybe Raul is maintaining his H status. And you know what his wife could do? Go abroad, get an H4 stamp, come to the United States on H4 status, and eliminate the 245K question.
Correct. But if she cannot,
sure.
The answer is yes, and we're assuming that the 180 day or less is true and accurate 100%.
Yeah, if you're within the limits of INA 245K, they should accept a case like that.
Yes,
and well, they're always willing to accept the case. It's whether or not they can approve it in the end.
Great question.
Yeah, it is a great question. We don't get many 245K related questions.
Yes.
And there it is, 245. I lost which question we were on. There we are, and there's that. And skip this one. There we are. So from Sagar, should anyone who has applied for downgrade consider refiling if priority date is August 2014? So that means you're going to be within the in the dates for filing.
So if you're an EB2, if you have an EB2 labor certification or an EB2 I-140, or you could file an EB2 I-140, and if your priority date is between July 8, 2013 and September 1st, 2014, you should seriously consider filing a second adjustment status, an EB2.
I mean, best, very limited chance scenarios. Maybe they think that maybe they actually have a plan to approve these cases in fiscal year 2022. Great, you got a green card earlier than you ever imagined. Worst case scenario is you have your case, you're in the EB2 category, and they're pre-processing your case, and sooner or later your date is more likely to come up in EB2 than EB3. It seems right now, at least. The
Cigar is the answer to the question is yes. They should consider EB2 filing and forget about chasing EB2 versus EB3. Not worry about it, in my opinion.
Okay. So, got green card, but gender is spelled wrong.
Oh.
That's gotta be a bummer.
Yeah.
Is it okay to travel with it, or should it get changed before travel?
I hate for you to travel with it. It might cause issues, honestly.
Yeah.
Honestly, it's probably not very likely to be caught, and your picture is there, and it's a fraud-proof document. It's clearly an error. If you file for a corrective document, you have to send back the card.
Yeah.
What a pain in the butt.
Yeah, and that's what drives me mad. So, Sam, I want to emphasize it. There is a process to get a corrected green card if they made a typographical error. The problem is, one, that process is going to take a long time. It's probably on Form I-90, would be my guess. One, it's going to take a long time, and two, you have to send in your green card to do it. And it would stress me out to no end to put my green card in the mail and send it
back to them
to a USCIS service center. I predict them losing that immediately. You don't
have a choice.
Yeah, I know you have no choice because you can
traveling without. I doesn't make you feel good traveling with it, Nagesh.
Yeah.
I don't feel good traveling with it.
It's like there's a reasonable chance that you'll have no problem, but if you have a problem, it's a massive one.
You get somebody on the border who's not very intelligent. It can really ruin your day.
Yeah, your day, Sam. I worry about your month if they say, no, we're going to err on the side of caution here, and you can go contact USCIS from your home
Well, they
country.
cannot deny him entry. They have to admit him and put him before deportation. Proceeding to see whether he's a permanent resident.
Deportation, Sam. That's a bad couple of years.
At least he's in the U.S.
Yeah, that's true.
Well, it's a pain in the butt. Yes, I'm sorry about that.
Yeah. So priority date 2014, July 2014, downgraded to EB3 in 2020. Should I refile an EB2 or interfile?
So you cannot.
I don't think you can interfile. Yeah,
because the
interfiling requires a current final action date,
which is July 8, 2013.
And you
for people born in India.
Yeah, and you are in July 2014. So
yes.
Yeah.
So I'm looking at my cheat sheet here. I was prepared for the questions on those because they're important.
Yeah.
But yes, you can file a second adjustment, but cannot interfile right now, which I am in favor of.
Now, see, Sam, I knew these questions were going to come up. When can I expect my priority date, December 2015, will become current in filing?
Filing date.
Yeah.
Well, the date for filing is September 2014.
Yeah. I would note the furthest that.
That's a long time.
It's about a little bit over a year. Sam, it is a long time. And then, whoosh. We got clocked in the face by a one-year movement on the visa bulletin. So
you're going to have it 2 months in a row. That's for sure.
Yeah. So Babu, there's nobody out there. There's nobody out there except for whoever is the new what's
Unknown.
the title?
Oh, and the title I have it written down here, but I don't.
The replacement for Charles Oppenheim at the Department of State, to our knowledge, has not been named because we were just looking up to try to figure out who that was before this thing. But that's the only person who has any sort of pre-knowledge on that. However,
Chief of the Immigrant Visa Control and Reporting Division.
Yeah. So it's Department of State who makes these decisions, but we have been surprised greatly this month. I don't know if I would count on another year movement, let alone a year and 2 months movement, Babu. But any movement ahead that doesn't include you is still good for you because that's just a little bit closer than you are. And I try to keep an optimistic outlook. The people in front of you getting green cards now, that's just a couple less people in line in front of you.
Yeah, absolutely, I agree.
Yeah, I encourage. Be nice to everybody else. Encourage everybody else to get their green card before you, because if they're ahead of the line, they're just means you're getting a little bit closer to the front of it. Yep. Question from Sai.
I have a job offer, but my priority date is March 1st, 2015 in EB2. Because of this date movement, I am not able to decide whether to accept or wait until October bulletin. Okay, well. May 1st, 2015.
March 1st, 2015. But
March 1st.
So that's not current yet. And
he's worried about it being current. Would filing a supplement J delay approval?
This is not a supplement J scenario, Sam. He's never been current. The furthest the visa bulletin has gotten on.
Yeah, but probably 180 days have passed. 180 days.
On his I-140. Okay.
On his I-140. Now he wants to move to a new employer.
Yeah.
He doesn't want to move. He wants to wait, hoping that the March 1st, 2015 will become current and he will get his green card.
Or to file for a green card. So he hasn't filed for a green card yet. That's the problem. It's basically.
He hasn't filed for the adjustment yet.
Yeah, because March. Yeah. So basically, as I understand it, Sai, basically, you're thinking, my priority date is so close, I'm going to be able to file for adjustment of status. And if I change employers right now, I'm going to have to go through labor certification and I-140 again. And what's the processing time for a labor certification?
A long time now.
About a little bit over a year.
5 months for the prevailing wage?
5.5 months for prevailing wage plus 6 months to get a case approved almost to the day. So you're looking at about a year.
Not counting a potential audit or something.
Yeah, and the time that requires to do the work in between. So
if your employer is above average, right now, above average, stick with them, in my opinion.
Yeah.
For another year. Until a year and a half. It's a long ride because you got to file the adjustment. You have to be in good faith, accepting his employment. Obviously, you should not be planning to change employment because you're signing off on that when you file the adjustment that you are intending to accept employment. And then after 180 days of that, you can develop an intent to move and then move.
Yeah, I will note the same. It's not impossible to have left your prior employer and still accept an offer of permanent employment. File. I mean, a common scenario in October 2020 is there were people who said, who sometime a year or two earlier said, I'm going to leave, move on somewhere else because my priority dates never become current. Then October 2020 happened, and then they called up their prior employer and said, hello, friends, my priority date's current now, and I'm nowhere near where I need to be with my current employer. I would love to join you guys on a permanent basis if you would still have me, and people have gotten green cards that way.
Yes,
yeah.
I agree. So that's a good advice from Brian's side. The movement depends on who's the employer and the situation.
Yeah.
But there is an opportunity to just discuss with them that I could come back later.
Yeah, and it really depends upon if it's a top grade employer, if you've brought them value and they want to have you back later in the future and they don't want to stifle your desire to do something else.
Yeah, absolutely.
It's really about can you intend to join whoever holds your your I-140 when you file an adjustment of status.
Absolutely, good point, Brian.
From Shanth.
My priority date is July 14, 2014. I have recently downgraded from EB3 to EB2 and have an approved I-140 EAD 485 in EB3. Do you suggest refile in my case this month or wait for a visa bulletin?
So this is where I have to refresh my memory as where the final action dates are back.
So he is before September 1st, 2014, he can file.
He's a year off of current. And, he's a year off. He's a year off final action dates in
July
EB2.
2000.
But he is current under dates of filing for EB2.
2 is exactly. So he can file another
He
adjustment.
can file it.
Do you recommend filing a second adjustment? Again, I do. I do recommend filing a second adjustment. I've had this philosophical, but that's my opinion. Now, I respect other attorneys that have different opinion. But for me, I always think about the upside of the deal, not the savings.
See, I always think about downside, Sam, because that's how I am. But I mean, but the downside of not you can, for this person, you don't file a second adjustment, and you say you wait for your final action date to be current instead they didn't file. But then again, you leave behind the EB3 category, and I don't like leaving things behind. I see. I want to have it all, Sam, and that's why ultimately, even though I'm a bit of a cheapskate, I say second adjustment because I want to have it all. I want to have every possible avenue available to me, and I don't want to leave one on the table. Because even though EB3 is behind right now, EB3 was ahead for. That's why so many people were able to file EB3 in October 20th. In the first place. It was ahead for such a long time.
Yes. So you realize that you cannot have your cake and eat it too. So you prepare to have 2 cakes.
Yeah.
And not eat them.
Yeah.
Have them ready.
Yeah, I'm not leaving any. I am not leaving any cake on the table. That's a Brian promise.
That's good. That's a good answer.
Yes. Oh. See, Jonathan has some follow-up questions.
All right. I refile my case. If I refile my case, can I travel to India and return on my H-1B status when the case is pending?
That's for the second adjustment. Yes.
Yeah, you're valid
The
H-1B.
policy allows people with a pending adjustment of status to travel on their non-immigrant visa and return pursuant to that, or H-1Bs and Ls. And there you go. The only thing I was to say is if you're going to file that advanced parole with your second case, expect that to be likely to be denied based upon the fact that they will often deny those advanced paroles.
So if you're going to travel for sure, don't file the advanced parole and file it when you return.
Yeah.
For the second adjustment.
Save yourself getting that scary decision notice, the denial, which on your advanced parole, even though it's not a serious issue.
Yep. Nobody wants to get a denial or a nasty decision.
It could be on the most innocuous case. I still don't want to see a denial from USCIS. It makes me feel bad. It ruins my day.
Yes, I agree.
So this is a good question. Flags me too. F1 student traveling on advanced parole with pending I-45. What happened to her F1 and SEVIS status?
Well, do you want to take it or take it, Brian?
I like this question because it's not related to F1 student status. But ultimately, when you enter the United States on advanced parole, you are not on F1 status, and there is no SEVIS. The SEVIS record should be terminated because you are not on student status anymore. That's the short answer.
Right. And your return to school on being a pending adjustee, I guess, should not create a second SEVIS for you. There should not be a second.
Well, the SEVIS is for the student visa program.
For F1.
Oh yeah, for F1 and a couple other programs, as I recall, and
MF and maybe J. Possibly.
Yeah, the bottom. No, I think J. Well, regardless, we can start talking numbers, letters and numbers all we want. But the bottom line is you're a parolee at that point, and you don't need any of that F1 status before because that adjustment status is incompatible with your F1 student status.
But advise your international student office at the school that you intend to leave and come back and to terminate your SEVIS with notation that student is re-entering on adjustment of status and will not continue on F1, so there will be no issues when you file your adjustment. The second note, which is not asked, but maybe should highlight that the chances of getting an F1 stamp it's not very, very low. As a matter of fact, there was one case where it was successful, but it's very low. It's low to get back on F1 if you have a pending adjustment.
Yeah, bottom line on that front is F1 status, you're not supposed to have immigrant intent to apply for adjustment of status. And if you come to the consulate saying, I'd like an F1 visa, and you tell them you have a pending green card in the United States, they'll say, well, enjoy your travel on advanced parole because we're not giving, not impossible, you're right, but if they're,
Agree.
So here we are. from Omkar Bujad. So in 2017 to 2018, SRC and LIN used to process 10K employment-based adjustment status each quarter. After 29, it dropped to 1,500. Did some process change in 2018? So in each quarter. So that seems low. Well, right now, because we looked at, I'll put up that chart again. Along. I see what he's saying. He's just talking about just those two service centers, and I think
I don't have the data.
Yeah,
and I don't have a good answer, but I would be curious to know. So I would like to go back and look. Omkar is bringing to our attention an interesting perspective.
Well, I haven't looked at the data pretty recently. I thought the Texas and Nebraska had proved about 33,000 some in the most recent quarter, but I could be mistaken, which means numbers are up versus that.
Yeah, I'll be curious to see what's going on there, but obviously, I'm speculating, diverting resources to other pieces.
No, I see what he's saying. He's saying 10. It seemed between them 10K, and now we're down to about like 3,500. And after 2019, I don't think
there may be more service center the processing adjustment than back in 2017 and 18.
Yeah.
Because the government in 2017 and 18, not specifically these years, but around that time, also were wasting a lot of green cards.
Yeah, but this might be, what I think might be the issue is that it's, around the same time that would have been the prior administration. Isn't that around when they started saying we're going to interview everybody, for a green card? So that could be something where basically the more local field offices.
Let's look at that.
Yeah,
and we'll get to you, Omkar, if you will be with us next week, we will try to answer that question for you.
Yeah.
All right, so 3 minutes left. Let's see if we can
so we have
answer
a couple questions left here. So here we are from Mohan. Looking at movement April 22, visa bulletin for EB2, do you think April 2015 will be current in dates for filing? My gut is telling no, and they'll retrogress due to a lot of interfiling and USCIS inefficiency. So I sympathize with you, Mohan. I'm presuming, that your priority date is in April 2015, and it is tantalizingly close for you. I am skeptical of their ability. Again, we're coming up towards the end of the fiscal year. There's about 6 months left in the fiscal year. And
well, that's not the end. That's midpoint, Brian.
Wait, what?
That's midpoint. We are at the midpoint of the year.
Well, yeah, we are at the midpoint of the year.
I'm looking at April 2015. He's September 2014.
It's pretty.
He's getting close, but not.
I thought it was crazy that it moved. The visa bulletin, the dates for filing moved a year in a month, despite the dates for filing moving only 2.5 months. It doesn't seem so crazy. I don't think anybody out there, unless they're the new chair of the whatever it is department at the Department of State, anybody telling you they know for sure that it's going to move that much. But honestly, this month has opened up my mind as to what the possibilities are. I am genuinely surprised by this movement. That's for sure.
Well, there's two shocking events. One, the movement by the State Department. Two, by USCIS accepting dates for filing.
They just, arguably, Sam, they already had gotten most of those. It's really interesting.
Unusual. Yeah. But we don't know really. Honestly, I don't have a prediction. But your gut feeling is probably my gut feeling, to be honest with you.
Big picture, Mohan. You are closer than you've ever been, and that's a good thing because
And I'm sorry to I want to prepare you for the next stage, because once you cross and you're current, whether you have already filed or will file your adjustment, then the next agonizing.
Until the green card is in your hand, you'll be driven mad by the government visa bulletin one way or another.
But definitely, with a current priority date is better than.
Yeah, I'd rather be tormented with a pending adjustment of status than still being.
I hate to be tormented by either. Both of them are painful.
Yeah.
All right, next one.
So Shanth. I have filed straight EB3 I-45 in November 2020. I have approved EB2 I-140. If I interfile once my priority date becomes current, would it cause a 180-day reset? Easy answer, yes.
Of course.
Yeah. Interesting. So when you say filed straight EB3 I-45 in November 2020, I wonder if his priority date is current in EB3. I guess.
I don't have the priority date. I was looking for that.
Yeah, I mean.
But yes, I mean.
I guess EB3 was so far ahead back in November.
If you interfile, so he moved the one adjustment to the I-140 EB2, the 180-day portability rule for adjustment is reset. Yeah. Yes, we'll take our last one today.
Well, this is more of a comment from Karthik with several Ks there. So love your support for the immigrant community. Still baffling for me the VB move so much given the in-app processing of the NBC Texas Service Center. Expect retrogression unless they pick up the slack.
True. I mean, yes, but again, we have the cynical view. We have the, what's the next one? The honorable view, and the third one is the...
I'm all for that honorable view. I want more people, again, the final action dates are going to do what the final action dates are going to do, but I am comfortable. I love the idea of just putting those dates for filing so far out before the final action dates. I want those final...
Let people file their adjustment, man. Yeah, it's a huge...
It's established that they're immigrating to the United States, so they don't bludgeon, keep them on a non-immigrant status until Kingdom Come, and basically have their roll of the dice every couple years when they need to file their H-1B. That's painful for people.
Absolutely. And with that, we end today's session. Thank you, guys. I know Brian wants to answer more questions.
I want to answer them all, Sam.
But yeah, we do. So come back next week and let's answer your questions next week. Thank you, guys. Have a great